So good afternoon, everyone. I am Christine Hausler. I'm the Dorset Senior Fellow here, and I lead the Center for International Law. It's my pleasure to welcome you all this afternoon on behalf of the British Institute of International and Comparative Law. So I'm very pleased that the topic of immunity is at the heart of one of our very first events of the year. Because indeed, in 2025, we are marking the 80th anniversary of the end of the Second World War and the start of the Nuremberg trial. You may know that Lord Shawcross, who was the lead British prosecutor at the tribunal and one of those who established the tribunal, was also a part of the group of signatories who established the British Institute of International and Comparative Law. That was back in 1958. So really, since then, the pursuit of international justice and the application of the rule of law, of course, have been at the core of our activities. Now, today, the question of immunity for heads of state remains a bone of contention between some states and the International Criminal Court. This, of course, jeopardizes the functioning of international criminal justice, as the court relies very much on the cooperation of its member states to arrest alleged perpetrators of international crimes. This issue has been very much discussed, of course, with the case of former President al-Bashir, and it continues to divide opinions with the more recent indictments of President Putin and Prime Minister Netanyahu, which have led to very different statements, and in some cases from the very same state. So the book that we will hear about today with our very distinguished speaker is extremely timely and very urgent reading. So we are very delighted to be hosting Judge Chile Eboe-Osuji today to present it. Among his many affiliations, Judge Eboe-Osuji is now a distinguished international jurist at the Lincoln Alexander School of Law at the Toronto Metropolitan University. He started his career in private practice in Nigeria and then in Canada. And he then joined public service, working as a legal advisor to the United Nations High Commissioner for Human Rights in Geneva, before embarking on a career in international criminal law, first at the International Criminal Tribunal for Rwanda, and then the Special Court for Sierra Leone. He then, of course, as you all know, became a judge at the ICC in 2012, and he became its president in 2018 until the end of his mandate in 2021. And I'd like to underline that during his time as president, he worked tirelessly with African leaders to correct the mistaken assumption that the court was biased against their continent. And this assumption that leaders from other regions of the world have now an opportunity to prove that it was indeed mistaken. So with this very important book, Judge Eboe-Osuji thus continues to support the role of the court in the fight against impunity with regard to the actions of all perpetrators of international crimes, including, of course, world leaders. So we will have about 40-minute presentation, and then there will be some time for a Q&A session. So please do keep your questions in mind. There will be some time at the end to ask them. So Judge, the floor is yours.
Very much for your kind introduction. And ladies and gentlemen, it's a great honor to have you here and to be speaking with you here in London, in England. There is also London in Canada, but London, England, there's a reason why I stress the England part. It is part of the story of the end of immunity. Now, the book came out in October last year. Let me begin by talking about the audience I had in mind when writing the book. I did not write it specifically for lawyers. I tried to write a book that the average person, anybody with at least a first degree out of a university in any subjects can follow either cared about what's happening in the world and asking these questions of what's going on. So the idea is to write a book that will be accessible to everyone, and by way of feedback. And at this part, if you're recording this thing, you have to edit it, right? So what's the feedback? Well, here's one of my brother-in-law, who's an architect, a businessman, he's not a lawyer, goes, "Chile, I have your book on my coffee table." I said, okay, that's quite flattering, but that book, was written to be read. So, but there's a second, so his dad, who was a doctor, not a lawyer, I've enjoyed reading that book, so he followed it. But more interesting was the verdict from a friend, Bill Shavers and I, a friend of ours, who was an engineer, who sent me a note, my email. I woke up and I read my email to Chile. Your book arrived at 11:30 last night, and I made the mistake of opening it to start reading. So, mistake. I couldn't put it down. Now, I'm saying this because the point is to say that it's good to have that kind of feedback from the kind of audience that I had in mind in writing the book. Now, the book itself, in terms of how it all started and what it's about, it is basically product of accumulation of research and reflection that started with me in 1997 when I joined the International Criminal Tribunal for Rwanda to prosecute the genocide there. And I was on the team that was prosecuting Colonel Bagosora. For those of you who know the story, and some do, Colonel Bagosora was the effective head of state of Rwanda during the genocide. The head of state had died in a plane crash on the 6th of April, 1994, and that's what the immediate spark to the genocide. So this strong man emerged as the leader of the country at the time, accused of complicity in genocide on the team. And then we had to prepare for that argument. The plea of head of state immunity. For some reason, they did not, in that case, plead because Article 6.2 of the Rome Statute would say there is no immunity for anyone, including heads of state or head of government. So that wasn't used at the time. But then the Special Court for Sierra Leone, a different story. I also worked there. In the case of Charles Taylor, I was in appeals. I was the senior appeals counsel in the Charles Taylor appeal. And there was a question of immunity. Now, I wasn't part of the team when that judgment was made by the appeals chamber of the Special Court for Sierra Leone. The counsel for Mr. Taylor had argued that that was immunity on grounds of it was only him being head of state, but also head of state of the country that did not subscribe to the agreement to set up the tribunal. The court dismissed the argument, but some academic murmurings continued after that, questioning the correctness of that judgment. So that kept the subject matter alive in my mind. So still reflecting on assessment of the reasoning of the trial of the appeals chamber versus the criticisms coming at the judge, who's right or who's wrong. So that was the second opportunity for me to engage with the question. The third opportunity was when I was at the ICC. Now there, I had to deal with the case. I presided in two cases. One at the trial chamber, the trial of Mr. Ruto, who is now the president of Kenya, was vice president at the time. At the time, the question came up, even the president of Nigeria, in his capacity as the spokesperson of EU heads of state, once gave a press conference saying that the Article 27 of the Rome Statute, Article 27 is the immunity, no immunity provision. That provision is inconsistent, contrary to customary international law, was what he said. I understand that he was not aware. An Indian PhD in in agricultural economics and like that. But I understand that a certain consultant from an eminent university in the UK had written an opinion, consultancy opinion to the African Union that gave that advice that Article 27 somehow was not consistent with international law. But in the Proto-San case, so the question did come up, dealt with it. So the third occasion was in the Al-Bashir case that Christine talked about, where I presided in the appeals. Now, in all of that, it became clear that there are stories and background to the question, historical background to the evolution of international law on the matter, which had been either underappreciated or not appreciated at all by certain people, including international lawyers, who are arguing that point. So I felt then it was important to provide that information to the public, that background information, and that is what is the product of all that collected in the book. Let me read a few excerpts from the book to set the stage. World War I decidedly changed the old view of war, when battles such as that at Waterloo represented the worst of epic battles beyond the age, when wars were fought with spears and swords and other rudimentary weapons. Fought in the open plains and farm fields in June 1815, the Battle of Waterloo registered a combined casualty figure of about 50,000 men for the armies of Napoleon and his opposing alliance of the Duke of Wellington and Gebhard von Blücher, the Prussian field marshal. In contrast, World War I saw claims of 1.4 million dead and 3.74 million wounded soldiers on the side of France alone, not counting those on the side of the British Empire and Italy. The burdens of this war, quote Dickens, Woodrow Wilson lamented later, have fallen in an unusual degree upon the whole population of the countries involved. I do not need to draw for you the picture of how the burden has been thrown back from the front upon the older men, upon the women, upon the children, upon the homes of the civilized world, and how the real strain of the war has come where the eye of government could not reach, but where the heart of humanity beats. International law had to be adjusted to meet the new threat. The British and the French government stepped up to lead the projects of that adjustment. In the remarks he made on the 18th of November 1918 to the Committee of Inquiry into Breaches of the Laws of War, the MacDonald Committee, Sir Frederick E. Smith, the Attorney General of England and Wales, the future Lord Birkenhead, framed the need for law reform in these terms, quote, "Our own view is that an aggressive war was forced upon the world by an ambitious and unscrupulous power, and that the challenge so developed involved the whole future of public law of states," unquote. painting a picture of the weakness of international law thus far in restraining wars of aggression and punishing how they were fought in fact, Smith spelled out what his government perceived of the attitude of Germany's leadership. Quote, in other words, he began, the challenge which proceeded from Germany meant this and it meant nothing else. We think that we are strong enough to conquer the world. Believing ourselves strong enough to conquer the world, we care nothing to roll the doctrines of international law. If we win, and we are convinced that we are strong enough to win, the inherent weakness of international law immediately makes itself manifest. In other words, inasmuch as we shall be the conqueror, inasmuch as international law has no sanctions which it can apply to the conqueror, it is a matter of the most complete indifference to us, whether in the judgment of those whom by our hypothesis we shall have vanquished, we have broken international law or not, unquote. Smith acknowledged that had Germany prevailed in that war, and they came close to doing so, quote, public law and the sanctity of treaties would have disappeared in our day and our generation from the world, unquote. Against that background, the British government took it upon itself to do its utmost, quote, to reestablish the authority of international law, unquote. To that end, Smith vowed that, quote, we are determined to take any steps that are necessary to reassert and to reassert under circumstances of the utmost possible notoriety, the authority of those doctrines, unquote. To the British government, the project of re-establishing the authority of international law in the light of World War I that was unleashed on international law, international community, so aggressively was a forward-looking project. As Smith put it, quote, with cool and passionate eyes into the future of the world, we are determined that our children and our grandchildren and those even who come after them shall be spared what this generation has gone through, unquote. He continued, quote, to us, it seems that the most effective deterrent of all is that for all ages, men who are tempted to follow the wicked and bloody path which the governors of the Central Empires have trodden during the last 4 years shall have present before their eyes not a picture merely of the brilliant and meretricious glamour of military success, but also the recollection that in this great conflict, punishment attended upon crime, unquote. Now, continue elsewhere. The law reform initiative that would deny immunity to heads of state accused of international crimes received early impetus from the majority of leaders of the Entente states in late 1918. At a meeting of the Inter-Allied Supreme Council held on the 2nd of December 1918, 4 days after his cabinet meeting of the 28th of November 1918, Lloyd George shared the report and conclusions of the subcommittee on law, which recommended that there should be punishment for the Kaiserfighter. Clemenceau and Vittorio Orlando, the French and the Italian premiers, respectively, endorsed the resulting position of the British cabinet. According to the minutes of that meeting, Clemenceau said, quote, that he thought he would show an immense progress if we could punish the man who was guilty of great historic crimes, like the declaration of war in August 1914. And he continued, all the governments represented here today were proud of the principle of responsibility. He continued sarcastically. As a rule, it only meant responsibility in newspaper articles and books, which the great criminals of the world could afford to laugh at. Of course, regardless of his doubts about immediately setting up the League of Nations, he still felt that, quote, a great step, however, would have been taken towards international understanding if the peoples of the world could feel that the greatest criminals, such as the ex-Kaiser, would be brought to trial. He therefore supported David Lloyd George's proposal that the ex-Kaiser and his accomplices should be brought before an international tribunal. With an eye to the future, Clemenceau considers that, quote, people everywhere would be satisfied if this could be done. They would feel that justice will in future be done in the case of Kaisers and kings just as much as in the case of common men, unquote. That, in a nutshell, is some of the key elements of the book. Now, what about the title, End of Immunity? Where did that come from? It comes from the fact that since that time, since 1919 up until today, now, most of us here are international lawyers, I imagine, for those who are not yet, or who are not. We know that one of the primary sources of international law is customary international law. And customary international law derives not only from what states do from their respective angles of the world, but also what they do when they come together in multilateral settings, such as what they do in declarations, they adopt resolutions, they adopt at the UN meetings and elsewhere, as well as treaties that they adopt. Those treaties and declarations, if they keep repeating the same norm, that is the source of customary international law. Now, from 1916 until now, there are a minimum of 16 instruments that have dealt with the question, do heads of state and heads of government enjoy immunity for international courts? About 16. And consistently, every time that question came in those 16 instruments, the answer had been no. Heads of state, heads of government, public officials, no one enjoys immunity before this international court was setting up whatever international court that was. So that has been the case. We also know that according to Article 38, 1D of the ICJ statute, the sources of international law, judicial decisions and teachings of the most qualified publicists of the various nations as subsidiary means for the determination of international law. And let's deal with the judicial decisions part of it. As of date, there are a minimum of 8 international judgments and decisions of international courts delivered by a minimum of 40 judges in those 8 judgments. And every time they have consistently said, no, heads of state do not enjoy immunity before an international criminal court in customary international law. So that is that from the angle of judicial decisions. What about writings or teachings of the most eminent publicists? Now, when Baron Descamps of Belgium, when he was chairing the committee that set up the Permanent Court of International Justice, where the formulation came from, the formulation that decisions of the courts and the teachings of the most eminent jurists of the various nations can be a source of international law. He explained that what he had in mind, or what that concept meant, was the concurring opinion of the most eminent jurists on the same question. That's why the French call it la doctrine. And in the French version of the ICJ document, it does speak about la doctrine des juristes plus qualifiés de différentes nations. La doctrine, it did not say des hypothèses. It's an hypothesis of various scholars. No, la doctrine, meaning all the various eminent jurists are saying the same thing. And here, let us consider that people like Arthur Watts, Robert Jennings from the UK, Antonio Cassese, Flavia Lattanzi from Italy, Alain Delay from France, John Dugard from South Africa. I could keep going on. These are some of the most eminent jurists of that time. And they've all said that there is no immunity for heads of state who commit international crimes, certainly not before international courts. So there we are. There is end of immunity. Now, one thing I need to stress here is when we're talking about, you've heard me say it repeatedly, we are talking about no immunity before an international court. I'm not talking about at the national level. Different considerations apply to that question. If somebody asks me the question about that, I'm happy to deal with it. But let me continue here. Today, talking about international court, the most prominent one now that deals with accountability in international law, international criminal law, is International Criminal Court. And as you heard Christine say during the introduction, the question of jurisdiction of the ICC continues to, stir that question to heads of state, heads of government enjoy immunity before the court. And that question comes at its highest when it engages the heads of state or heads of government of states that are not parties to the instrument in question here, the Rome Statute. What about that? Now, that was why, remember I said in the Charles Taylor case, the murmurings, the academic murmurings that continued, had to say, well, the Special Court for Sierra Leone was established by agreement between the UN and the government of Sierra Leone. It did not involve Liberia, so the government of Liberia was a part of that agreement. How come the court is exercising jurisdiction? Can it be right? So that has been the question. We see the question, as again said during the introduction, asked in the context of the Russia, the arrest warrant against Mr. Putin and his senior colleagues in government. The question has been asked about the head of state of the effective leader of Myanmar, right, whom the ICC also requested an arrest warrant, Mr. Khan requested an arrest warrant against. Myanmar protested. We are not party to the Rome Statute. On what basis are you exercising jurisdiction? Mr. Khan's arrest warrant of the ICC judges granted against Mr. Netanyahu, again, the same question asked. Now, those who are asking the question, not only the government, but also their allies. Sometimes the allies who are saying, well, do you really have jurisdiction to arrest and try this person before the ICC? Will turn around and say, yes, the other person, yes, of course, you must arrest him. It's the right thing to do, notwithstanding that the two states are in identical position of not being parties to the Rome Statute. Now you begin to say, well, perhaps the argument, of course, is based on consent, treaty law. I'll come to that in a minute. You begin to say the consent argument lacks integrity in the mouth of politicians because of the flip-flopping you get. But in fairness to politicians, it's not only politicians that raise that question, academics do too. And that's, again, part of the reason for writing the book. So that brings us to the question, should it be correct to say that the ICC may not exercise jurisdiction in relation to heads of state or heads of government of a state not party to the Rome Statutes? Are they correct in the objection that the ICC should not exercise such jurisdiction? So let me now get to the meat of that question. Let's move on now. Here is one proposition there, one route to get to that point. I don't know how many people in the room are not in my class at TMU to say, okay, show of hands, who knows what jus puniendi stands for? I'm sure some of you do, but for those who don't, the phrase there stands for the right to punish, the right of society to punish jus puniendi. Punish for what? The right of society to punish those who transgress the most basic norm that glues that society together, or those who transgress what I call the preservable norms of international law. Preservable in the sense of society may get together for purposes of self-preservation of its individual members, be it individuals as human beings here, or states getting together. They want to get together because they want to preserve themselves. And by virtue of that, they also necessarily want to preserve that unity that preserves them, that community that preserves them. So that's what I mean by preservable norms of international law. And there are two academics who've made that concept relevant in the context of discussions concerning the ICC. These are jurists of our own time. Professor Kai Ambos from the both Germans, Professor Klaus Kretz. They use that concept to try and explain the doctrinal basis of the jurisdiction of the ICC. Now, when they did that, it was in the context of a certain debate. How do we explain that jurisdiction? Some scholars came up with a certain theory called the delegation theory. So you explain it by way of delegation. The various states parties to the Rome Statute have delegated their jurisdiction to the ICC. Personally, I think that's a terrible theory, terrible hypothesis. Somebody can ask me later why, but I have to move on. Now, explain jus puniendi first. Now, but what Kai Ambos and Klaus Kretz do with the theory of jus puniendi may have been done in the context of trying to explain the doctrinal basis of the jurisdiction of the ICC. But what they are saying resonates with customary international law back to the era when it used to be called the law of nations, even before when it used to call natural law that guides relations between nations, and even earlier than that, back to the time of the Roman Empire. Some of the people whose writings deal with that you'll see there on your screen. Let's begin with H.L.A. Hart, nearer to our own time. Remember, the argument against the jurisdiction of the court a term by a court exercise jurisdiction over leaders of states not party to its constating treaty, comes from the notion of consent and treaty law. While that state did not, it's not a party to the treaty, so they've not agreed to it, so they've not given consent to the authority of that court. So the court cannot exercise authority, goes the argument. Well, Hart tells us that the doctrine of consent in international law is overrated. He says that it is something that sounds more in abstract dogma than a real practice of in real examination of the facts, to say that hard. So the consent, he said, does not explain all the adherence that state, particularly new states, give when they join the international order. So consent doesn't explain everything. By the way, he continued, consent, the idea of consent is actually logically inconsistent with its own premise, in the sense of saying, well, if you're going to say that the only time a state can be seen to be bound is when that state has given its consent through a treaty. And Hart asks, well, by what theory do we arrive at that bindingness? It could not have originated in itself. There has to be another basis, juridical, normative basis that will validate the idea of bindingness, even in a treaty. You have to find the source of that validation somewhere else. It cannot be in treaty itself. The says treaty is binding. Where do you get that from? Now, Lord McNair and Fitzmaurice also make that point, that treaty law does not explain all of international law. Treaty law is a subspecies of international law itself. Treaty law derives its own validity from a broader norm, and that's not treaty law itself. There has to be something else. And that something else includes, naturally, customary international law. So there you go, goes Hart, that consent can be overrated in the discourse on international law. Back to jus puniendi, the right of states to punish. That theory goes back to the time of, certainly, Augustine of Hippo. In his conception of the just war theory, he said there are three conditions for just war. The first is that the war itself, for it to be just, has to be made under the authority of a sovereign. People are not entitled to engage in private war. So that you need the authority of the sovereign, that's number one. The second condition is that there has to be a just cause for the war, in the sense of some fault. I'll come back to that in a minute. But then the third condition is that it has to be with the right intention. So you're not going to go fighting a war that's just on the basis of self-aggrandizement, on the basis of hate, on the basis of warmongering, heroism, and all that. There has to be right intention. So those are the three conditions. Now, back to the second condition, there has to be a just cause, of course, that's the anchor of the whole thing. So he said, in the conception of what was a just cause, it means that there has to be some fault. And the some fault condition requires that even the violation or committed against innocent third parties can give you a just cause for, not just violations done against you. So you can vindicate the victimhood of a third party, a third state. So that was St. Augustine of Hippo. Victoria, Francisco de Vitoria, Francisco Suarez, in their own time, these are Renaissance scholars, also carry that forward, said states can engage in the right to punish other states for violation of those principles norms of international, including violations committed against innocent third parties. Victoria and Suarez say that Gentili and Grotius carried that forward in their own writing, the same theory. Gentili, people don't talk so much about, but he was a bit of a contemporary to Grotius, a little older in time. But Grotius, everybody calls the father of international law. Hugo Grotius made that point very, very clearly. And again, like the idea of you can vindicate violations against innocent third parties, he saying the same thing. It's not only your right to exact punishment, it's not only for violations done against you, you can also exact punishment for violations done against innocent third parties. So that was the extended theory of the right to punish. Vattel had problem with that to an extent. Vattel complained, well, yes, I accept that you can exact punishment against transgressions done to you. My difficulty, complained Vattel, is with the extended notion that you can extend it against violations done to innocent third parties. To do that, he says, would be to open the door to the ambitions of ambitious men without number. So he complained, you cannot do that. But before too long, the same Vattel tells us that, well, the international community has an obligation of mutual assistance to one another. So when you see your neighbor suffering, you have an obligation of mutual assistance to your neighbor or to a third party. And in doing that, you are acting as members of the international community. And it's important to do that because no one can stand alone. Any state that thinks they can stand on their own will sooner or later find their own rights being violated, their own rights of self-preservation being violated. So the same Vattel that began complaining about the right or the extended notion of the right of exaction of punishment now comes back to it in his theory of mutual assistance. So Vattel joins in that idea of the right to exact punishment. Jus puniendi in connection to rights, a violation of rights, not only of yourself, but to innocent third parties. Now, Hans Kelsen tells us that when you exercise that right to exact punishment, you are exercising it on behalf of the international community. Even though you're doing it on your own, it's best if the international community can come together and exact that right. But when they don't do so, and individual states are exercising that right, they are exercising that right on behalf of the international community, because the international community has a monopoly on that exercise of right to preserve itself. So that is the theory of Hans Kelsen. Now, let me go back to Suarez. We've been talking about this right to exact punishment. Of course, in the conception of the right, in the order of just cause theory of Augustine of Hippo, the way usually you talked about that, or the writing has been, is that you go to war to vindicate that right, the right to exact punishment. You do it by warfare. But Augustine's theory of just cause says you need not go to war if the state in question makes amends on time to punish whoever it is of their citizens that are engaged in that violation, then there is no just cause. The just cause would arise if that state refused to make amends, if that state refused to punish its own citizens who actually did their violation. So the state can go to war. So in that sense, means you need not go to war. If you make a demand and the demand is acceded to, that's the end of the matter. Your right to go to war has been removed to that extent. So the theory of using means less than violence, you see right there. Now, go back to the time of Livy. So I bring him up on this at this stage. Livy lived during the time of the Roman Empire, and he wrote about the festal priest used fetialis, how the ancient Roman institution of festia, college, collecting fetialis, was organized in order to make demands of a state that had violated the rights of Rome. You had the federal priest organize himself. You had the leader, the pater patratus, who would do certain incantations along the way in rerum repetitio. Rerum repetitio, you repeat the demands of Rome. They do that. The pater patratus would commence one's violation. They're the ones who decided whether or not Rome could go to war. Along the way to the opposing city or opposing state at the border, he will incant or rather recite Rome's demand for reparation. And once crossing the border, he repeats that recitation to the next citizen of the opposing state or city-state about Rome's grievance. And on the way towards the forum of the city, he will do that until inside the city forum, he does the same thing. And if the state in question, or the city-state, does not make amends within 30 days or 33 days, the pater patratus will return to Rome and report that, well, there is no amends coming, and then it was up to the emperor from at that point to declare war. They did that for purposes of ensuring that war was not something that resulted automatically from violation. War was something that could come after failure to make amends. Okay, so that was the time of the Roman Empire. Move that up to Suarez. Suarez tells us, yes, the usual way you exacted punishment was through war. But he said, if you can exert punishment without going to war, that would be the better course to follow. We see that happen in the idea of setting up an international tribunal to try violations of international law. The Nuremberg Tribunal, the Tokyo Tribunal at the end of Second World War. Robert E. Jackson made the point, we need not use violence all the time to punish those who commit transgressions of international law. Sometimes the best approach is through what we're doing here, the Nuremberg Tribunal, said Robert H. Jackson. And we know that the progeny of that project of international criminal tribunals is what? The ICC. The Nuremberg Tribunal, let's keep in mind, was created by states who entrusted the court to exercise jurisdiction, regardless of the fact that Germany was not a party to the London Treaty of 1945. When Douglas MacArthur established the Tokyo Tribunal in Tokyo, International Military Tribunal for the Far East, he did not ask the consent of Japan to set it up, and yet the court exercised jurisdiction. So The story is that we now see collecting or culminating into the Rome Statute, before that, the Nuremberg Tribunal and the Tokyo Tribunal, the idea that an international court can indeed punish those who transgress international law, even though that states were not party to the instrument that created that court. And it is, ladies and gentlemen, an old concept in international court. We can call it jus puniendi, and I'll leave it at that and take any questions you may have. Thank you.
Yeah, I think we have a couple of roving microphones for you to ask your question. Thank you first very, very much for this sort of tour de force, really, of anchoring your message in the doctrine and going back all the way to the Roman Empire. I found it really fascinating. I certainly learned a lot. Perhaps while people gather their thoughts and think of a question, I'll perhaps ask one. This event actually also came about as we are part of the same group. I do share one affiliation with you, which is a PLPG, the Public International Law and Policy Group, and they work to support roads to peace processes. So my question to you, what would happen, for example, I have seen one state, not perhaps an official declaration, but there's been report that some states may perhaps provide for at least temporary immunity for the purpose of engaging some world leaders such as Putin in peace discussion on their territory. So do you have something to say on those possible temporary immunities, or more widely on immunities in relation, immunities from projection in relation to peace processes, peace agreements?
Thank you. The answer to that would be that in the conception of the absence of immunity, there is no exception made to say, well, there is no immunity except when you are attending a peace conference. And we've seen instances where even in the context of I mentioned Charles Taylor, that was exactly the scenario. Charles Taylor was in Accra, Ghana to attend the peace conference when David Crane, the prosecutor of the Special Court of Syria at the time, served him with his arrest warrant in Accra, walking into the hall. And of course, Charles Taylor promptly got on the plane and escaped. The Kenyan head of state was not happy about that, but he did not. So the point is to say that he had no exception to the rule against immunity. The norm doesn't recognize that, in my view.
I think it's good, a very clear message. I think it's also very helpful when you see what's happening. When recently we see the situation with Italy of letting go of alleged perpetrators back to their country. So an ongoing issue. So anyone has any question here in the room?
Joshua, thank you for your talk. My name is Tatevi Davi. I'm a barrister at One Mitre Court Buildings. And I think I was an intern at the ICC when you were at the court in 2016. My question is, well, we've seen states invoking not the principle of vertical immunity to say that heads of states cannot be prosecuted by international courts, but rather saying that they have issues exercising criminal jurisdiction over heads of states. We saw that argument with African states saying because they signed the Malabo Protocol that they weren't able to arrest sitting heads of states. And we saw the subsequent request for an advisory opinion at the ICJ. Have we seen the end of those kinds of arguments, or do you think that there's still scope for them to reemerge in future, this idea of horizontal immunity stopping heads of states being brought to justice?
Thank you. As a matter of politics, and a lot of this has to do with politics, you find that heads of state are not always consistent, or politicians who take these positions are not always consistent in what they say. In one breath, you would have, for instance, of course, when you introduce the subject, you did not name names, but let's try and do so. People would think, well, you would have the Biden administration, for instance, say on the one hand, yes, it was a good thing, and the Rishi Sunak government at the time, yeah, it's a good thing to indict or to issue an arrest warrant against Mr. Putin, but no, you cannot do that against Mr. Netanyahu. He's an ally. But it wasn't only those. That's not the only time we've had that argument. You had Brazil say, well, in relation to arresting the head of state of Russia, but it's not a state party to the Rome Statute. Russia is not. So ICC should not exercise jurisdiction. But yes, the Israelis are committing genocide. It will be the Brazil's position, and there needs to be accountability for that. So you have that kind of flip-flopping from the same people. So politics can say anything. That's one. But as to the normative question you asked more seriously, the horizontal immunity argument has been raised in the context of saying, well, and this may well be the time to talk about, the immunity state-to-state relations. If it is accepted that we cannot exercise our own jurisdiction as states against the sovereign of another state, and they cannot do the same thing to us. Okay. And if that is a correct position, on what basis then are we supposed to be arresting sovereign and sending that sovereign to the ICC? And that is a question that can be entertained and discussed. And that discussion was done in the al-Bashir judgment, in the separate opinion of 4 out of 5 judges. Don't ask me how that came about. Now, the argument is to begin to find what is a rational basis for the horizontal immunity, state to state. If it comes from the concern, a valid concern that, well, because of reasons of sovereign equality of states, I cannot exercise from head of state jurisdiction over you. And so it's all right, one can see that. And then you go back to when that norm was established in, parenum habet imperium. You go back to how, when that norm was clearly articulated in 1812 in the Schooner Exchange case by the US Supreme Court, 1812. You find that most heads of state at the time were royalty, the monarchs at that time. And there was a principle at that time that was very, very strong. What was that? Rex non potest peccare, the king could do no wrong. The king was above the law. In his realm, you drive by Old Bailey, says the royal courts, where you practice. Okay, royal court. You go to Canada, there's a crest behind the judges in Superior Court sitting there, Royal Court of Arms. That reminds everyone, this is royal. There was a time when King Sunton was told, I said, look, the king who wanted to exercise actually sit in judgment, literally. So no, you can't do that. Okay. There was a time when King sat, dispensed judgment. King Solomon wisdom that is traceable to that. The wise judge was a king, administering judgment at the time. So there was a time when you saw kings exercising judicial power. And that concept remained even when they stopped doing it in practice. The idea itself remained that the court belonged to the king or the queen. All right, then you begin to see the difficulty with, well, if the court is my court, I'm the head of that court, and in that court, I cannot be tried because I'm above the law. You see the difficulty with trying you in that court. That immediately throws out the concept of equality of sovereigns. And it makes sense in 1812. That would be the case. But fast forward to, remember in 1812, we did not have an organized multilateral international society. Not even 1889 to have that. The first time the idea of a multilateral system took hold was then 1920 League of Nations, the very first time. And new norms set in at that stage. And the norm being, if you now have an international court that is nobody's court, it's not a court that belongs to any sovereign as their own, you don't have that difficulty about equality of states being transgressed when that court exercised jurisdiction. And we say in the Habashir case, that on that basis, a state that is arresting, exercising this power of arrest of senior officials of another state and sending to the ICC is acting not on their own force to exercise the jurisdiction in that territory, but to send that person to another court that has claimed jurisdiction that has a valid basis to exercise that jurisdiction. So the complaint remains with the court itself, the international court, and not with the state that affected an arrest warrant that they are obligated to arrest, to effect. And by the way, that obligation to arrest, to effect the arrest warrant is one that the states who are parties to the instrument had undertaken. So if you have signed a Rome statute that says no one enjoys immunity, including you as head of state, that's an obligation you have. You then, and that obligation also says you have an obligation to arrest whomever the court issues an arrest warrant against and send it to the court. That is an obligation that's on you to exercise. So your complaint is not you doing something on your own by virtue of your own national law, but by virtue of you being a member of an international system that requires you to exercise that obligation.
Yeah, I think we have time for one more.
Yes, hi, I'm Anthony Winton from Bickle. Yes, so I've had the opportunity to read your book. I also couldn't put it down. I highly recommend it to everybody. Yes, well, we're on the national level. I wanted to go back to the ICJ's arrest warrant case, if I may. So, as you know, the court declared that with respect to foreign national courts, they were unable to deduce any exception in customary international law from the rule according immunity to heads of state, heads of government, foreign ministers. But then I also note in your book, you say just because the ICJ bench cannot deduce this point of international law doesn't mean that another jurist of equal stature might not be able to deduce it. I think, and here we are. We have our jurist of equal stature here with us today. So I'm just wondering, what is your assessment of that pronouncement that there was, you cannot find customary international law that questions this absolute immunity?
Thank you. Thank you. Let me be clear. When I said that, I wasn't referring to me. When I said jurist of equal stature, I was referring to Antonio Cassese. And I said to made it very clear in the book. Yes, Antonio Cassese had faulted, in my view, correctly, the the analysis of the ICJ on that point. The ICJ on the point was what in the words of Judge Higgins and Goodman, I believe, and Wagenthal in their separate opinion, said that they are less than sanguine about a certain point. So that was a less than sanguine point. There was no confidence in that statement that we could not deduce. It was not an authoritative statement that there is none. Simply we could not deduce, meaning, well, we're not quite sure. But then we have to say something. My view is, as cases rightly pointed out, is that there is important authority in international law on that question. That and the restaurant case, remember, did not have the ICC on international court in mind. Even the ICJ in their restaurant case, they said, well, we do recognize that an international court, such as International Criminal Court, when it has jurisdiction, can do that. I believe they said something to that effect. Their point was that Belgium could not exercise a jurisdiction over the former foreign minister of DRC. So that was a horizontal issue, state-to-state issue. And they said we could not exercise. And the argument was, well, even in that horizontal relationship, is there an exception for international crimes? Quite a separate matter from, let's say, you are arresting a head of state for corruption because there's, a sort of corruption of some other reasons. For international crimes, can that be an exception to immunity, horizontal immunity? And the ICC said we could not deduce that there is an exception even for international crimes. So that's what they said. But because as I said, well, there are authorities to show when heads of state have been tried for others, for international crime. And he gave some instances, and I agree with him. A lot of, perhaps the litmus test for that, if I may cut to the chase in a dramatic fashion, was during warfare, for instance. Okay, two states are at war. I've often wondered why there's a strong hoopla if one state captures the head of state of another state and summary executes that head of state. You don't get a lot of argument about summary execution of a head of state of another state in the context of war. People may say, okay, wait, they shouldn't have done that, but you don't get extended debate about that. But put that person on trial, oh no, you can't do that. And you're wondering what are the priorities? Okay, so yes, you can carry out the ultimate punishment against this person, that's all right. But no, you cannot try that person. Or less than summary execution, you can even exile them from their country if you have power to do so. So never come back here. Okay, which in itself is punishment, to be exiled and from land where you love and your family and friends, you can't see them again. That is punishment, like sending you to jail. You can do that, but for international trial or for trial, you can't. And Robert A. Jackson puts the point quite well in his opening speech in Nuremberg. He said, these people may complain that they're being put on trial, but they are not hard done by, because they could have been shot on side, but here they're not being shot. They are given a chance for fair trial where they can marshal out evidence, rebut the prove beyond reasonable doubt concept. And at the ICC, for instance, don't forget that an ICTY, ICTR, there are acquittals of people who have been tried. And these people will have a chance for an acquittal. But people complain about that and saying, what is all this bad? So that's part of the analysis that goes into that question. Thank you.
So final question, because we're going to be running out of time.
Thank you very much. My name is James Schofield and I'm a barrister. I'm conscious that I'm surrounded by a great deal of scholarship of international law, which I don't possess. But I would like to ask this question, if I may. It seems that some European states have said that if the Prime Minister of Israel was to visit, they would arrest him. Others have said they would not arrest him because he's protected by the law of immunities. Is it your view that the issue of his legal immunity is an issue to be decided at The Hague following his arrest rather than by the arresting state? And that they have a duty to arrest, and that the issue of whether he has immunity is something to be considered later on?
Yes, the latter will be my view, that the issue of immunity is not for the state to have that obligation to make that determination. It is a litigation that needs to be done where it belongs, and that is at The Hague. And the heads of state do not have the right to interpret the Rome Statute in a way that binds constrains the jurisdiction of the ICC. So my answer would be that. Now, on it, the question you asked, you didn't ask this question, but this gives me the opportunity to engage it because it often comes up in the context of these political statements by states. France, for instance, said that. Now, one thing that people seem to miss in pronouncements like that is that ultimately it's really not up to politicians to decide that question, even in their own countries. For the judges and the prosecutors to do that. Now, whether or not to arrest and send to the ICC. But there's another angle to it again that people seem to miss. What is that? Well, universal jurisdiction. Universal jurisdiction is a concept that originated, as it were, well, I don't want to say originated, but came into because it was there during the piracy era and all that sort of thing. But the Second World War, or the Geneva Convention rather, gave it a certain impetus. There is a provision in the Geneva Convention, 4 Geneva Conventions of 1949, that imposed obligations on states to either prosecute or extradite to a state that claims jurisdiction from such a case anyone they find on their territory who committed war crimes, regardless of nationality, presumably where the crime was committed. Geneva Convention started, and then you see that now in modern instruments of state to transnational criminal law. Out you carry, they call it in Latin. The Europeans have been, especially Germany, France, Sweden also, tried an Iranian for war crimes committed in Iran. Right. Germany has exercised that jurisdiction. France does it. As a matter of fact, before Bashar al-Assad was run out of town, the French courts, the first instance and Court of Appeal, decided that yes, even though he was head of state, he could be tried in France on the basis of universal jurisdiction and that he had no immunity. The French courts have said that. Now, the case of the final appeal to the Court of Cassation, the final court, we're waiting for that judgment. So the point is, you now see prosecutors in Europe exercise that right. It's not about really trying the person at The Hague, but prosecuting the person in their own national jurisdictions. And the politicians can't really make that call or prevent it from happening. So that's another missing piece to all these calculations. They can give some of these people false hope that, yeah, your ally, come on over. But if the prosecutors say, no, we're going to try this person, it's interesting to see whether they really is confidence or safety given to their allies who travel.
Thank you very much.
Thank you. No, that's a great point. Also, it fits with the court's principle of complementarity, right? So thank you very, very much for your time, for your generosity, for this very inspiring, very well-informed lecture. We're very grateful. So I think that deserves another final round of applause. Thank you.